Welcome to Property Deconstructed with Mark Aricallo from Master Advocate Real Estate Services. I'm Pat from Tell Your Story Media, and this is a collective wisdom of everything with property and real estate and all the joys involved with property and real estate. And we invite different service providers into the studio to chat about the different things when it comes to the process. And we're talking about the law today. Mark Aricallo, welcome back, mate.
Hey, thanks, Pat. Thanks for having me back. Always glad to be here. Yeah, when purchasing property, the law and risks involved and due diligence, very important to protect your future as well.
Yes. And there's always hidden things in there with contracts and things that you need an expert to point out to you, because you don't want to get to the signing bit and think, oh, I didn't know about that part.
Yes, yeah, of course. Everyone's got a different appetite for risk, and some people take a lot more risk, but we'd never advise our clients when buying to act without getting solicitor or conveyancer or solicitor and legal advice and pre-purchase risk assessment of contracts.
You'd be crazy not to, don't you reckon, Mark?
No, you would be, and a lot of people still do it. They think they just need it once they've purchased and at the conveyancing end, and that's the important step that we're going to talk about today.
We have a special guest.
We do. John Melia of Melia Lawyers, and for the sake of transparency, John's been one of my very close mentors. He's actually my brother-in-law as well, but he's been kind enough to share a lot of wisdom here today, and give our listeners some tips.
Welcome to the show, John. Thanks for joining us, mate.
Hello, Pat. Hello, Mark. How are you?
Good. Does Mark pull you up at every barbecue and sort of pull you aside and try to pick your brain at every family get-together?
As much as he can,
yeah. You don't mind that, do you? I do the same. Because we sort of move in similar circles, so I've been on the phone to John a few times as well.
Always a disclaimer that it's not direct legal advice, but we're just sharing some tips here.
Yes, that's right. I mean,
yes. So basically, any advice that you need, you should get your own advice in relation to anything specific, and this is advice of a general nature, and you should consult a lawyer.
Okay, yeah, it's good to say that, of course, because we're trying to do our best to give general information through these channels, but take what we give you and then, you got to ensure it suits your unique situation. Talk to a lawyer.
Exactly.
Yeah?
Correct, yeah.
There's a book and there's a podcast and there's other things that you do as well where you share this information.
Yes, correct, Pat. So at the moment, I've got a couple of podcasts that are floating around. There's one called Legalese Australia with Tom and Jonas.
Oh, yeah.
And we invite barristers and other experts on and talk about the law and break it down. And I'm also in a series put together and run by Kevin Hillier.
Yes.
And it's called The Legal Minefield. Right. And that's on as well on the channels Spotify and
great listening. Even though I've had John speaking to me all my life, I love tuning in and listening and learning on that show. And then you've got your book that's been released as well. That's more for education for lawyers, is it?
Yes, it is. It's for the training of young lawyers. So it's about legal practice in Australia, and it's just giving them the basic tools with which what to do and how to do it when you start working in a law firm.
Great. Now, I know you cover different areas, but let's focus on property and the fact that you're purchasing a property. Mark, when does all the legal start and how does it happen?
Well, it should start as soon as we've targeted a property. As buyers advocates and independent buyers advocates, we always advise our clients as soon as we've shortlisted a property and the contracts of sale and Section 32 is available, it's time to bring in the team. If they don't have their own legal representative, we'd recommend one for them. And that's where we'd start with, in this episode, talking about, the solicitor and pre-purchase review, contract reviews, terms and conditions, the due diligence steps, John, that you'd highlight, or risks that people make that you see common mistakes.
Yeah, so effectively, if you're buying a property, you need to do your due diligence. And what we mean by due diligence is have a conveyancer or a lawyer review the contract. So in the contract of sale, there'll be general terms, which are the general terms, for example, when you pay the deposit, what happens with settlement, etc. Then what people like to do is add special conditions. And the problem with that is special conditions vary or change the general conditions in the contract. And special conditions also affect purchasers' rights and abilities to make claims or do things down the track. So it's important to get those reviewed so you know what they're doing. So basically, in simple terms, they're trying to alter the standard contract that you're going to sign when you buy a property. And that's to their benefit, not your benefit. So it's never to the purchaser's benefit. It's always to the vendor's benefit when that happens. And that's why you need someone to have a look at them. So, for example, in the contract, there might be a clause in the general terms that says, for example, if something was not right with one of the representations made by the agent, the selling agent or the vendor, you can do what you need to do to take action. They'll have a special condition saying, well, we don't make any warranties or representations and you can't come after us. So that's the type of example of things they'll do. So basically a purchaser will get the following. They'll get a contract of sale and a Section 32 document. A Section 32 document is required under the Sale of Land Act in Victoria. The reason that came about is basically to give purchasers some sort of advice about the property they're buying. So there are mandatory items that have to be in a Section 32. So in a Section 32, there'll be a title search with the title particulars. There'll be a planning certificate to see if there are any planning restrictions. There'll be a roads certificate. There'll be council rates, water rates to see what the rates are involved. Then most importantly, there should be also if there's been building works by the owner, there should be a builder's warranty insurance certificate, an occupancy permit, etc. If it's an owner builder, then within 7 years of building, you must have an occupancy permit, owner builder's warranty insurance, etc. All these things have to be disclosed. If they're not disclosed to the purchaser, then the purchaser will have the right to pull out of the contract.
Right. And so you need somebody to run their eye over the Section 32 and make sure all those elements are in there, or is it?
It is. It's the pre-purchase review from solicitors like John would actually be highlighting these parts that were disclosed or needed to be disclosed, and at least the buyer, if they're not aware, sometimes they make assumptions with what can be done with the land. There might even be some, certain covenants that they weren't aware of, or easements, even caveats and things like that. That at least the legal representative and solicitor can explain them before you step in. You may still want to step into the purchase, but at least you know the law of the land.
So how early I'm putting myself in the situation, purchasing a home, I'm looking at the Section 32 and it's got those elements where you think, I didn't know that.
Yes.
So you're getting it quite early in the process?
Straight away during negotiations.
Yeah, as soon as the contract's
as soon as you say, I want to purchase that property.
Yeah, before you sign anything.
Right.
And as soon as a contract's made available to you from, say, the sales agent or vendor, if they're selling it privately, they've had their solicitor prepare it, then you'd get the review as soon as it's in your hand, that hot minute.
Right. So I should always be saying to everybody when purchasing a property, look, I'm interested, but I want to see the Section 32, and that starts
correct,
the process.
And you want to see the special conditions in the contract.
Yeah, right.
Special conditions are the ones that come up tricky, even with penalty interest and things like that. That as a solicitor, you always highlight for us in our purchases, because if a client's going to default at settlement, I've seen that being changed and manipulated a lot by solicitors preparing contracts. Is that right, John?
Yeah, so for example, the standard interest rate will be under the penalty interest rate, which is about, 10%, but they'll add maybe an extra 4% or 6% on top.
If you don't settle on time. So that means on a daily.
Yeah, so if you don't settle on time, you pay that percentage on top of the sale prices on a daily basis.
And that's one
quite
you should
hefty.
say.
Well, yeah, and it may not be, sometimes it is the purchaser's fault why there's a delay, but it could be one of the parties on their side, bank other reasons, and you're paying that daily interest until you sort it out and risk the other party, the vendor, rescinding the contract, and that risk can hurt people's position as well.
Yes. So do you just send it back and say, look, I don't like that special condition, it needs to be removed?
Yeah, I'll instruct the client to say this needs to be removed before you sign, and this is the reason why. And then they'll take it off.
It's those who think they can do it on their own who might sort of not see that mark, and then because does anybody ever resist that, John? When you say remove that special condition, and say, well, we're not.
Yeah, you will get other solicitors who've drawn the contract or conveyances resist it. and tell their vendor clients no. And then at the end of the day, we tell the client, look, you're at risk if you agree to it. It's your decision ultimately whether you want to take that risk, but we advise against it.
Right.
Yeah.
Okay.
And I guess it depends on the market, time in the market, sentiment. If they've got a lot of hot buyers making offers without any conditions or resistance, they'll take the easier target. So you've got to then decide, how much do I compromise? What risks do I take if I really want this property? But at least you've had your legal advice.
Yes.
You know where you stand. But
yes. I've got a word for us. Leverage. Is it leverage, John? As Mark says, it's all, as the market shifts, you leverage, you might be on the good end of it all, as you just take what you're given in a way. If the market's quite hot, you've got to sort of evaluate all that.
And all the advisors,
It's leverage, Pat. It's always down to leverage.
Do you have a chapter in your book on leverage?
No, not for the young solicitors, no.
There you go.
Well, that's
for Pat Panetta.
Yeah.
My chapter on leverage. So there you are. You got to sort of evaluate the whole sort of picture and work out what you can and can't sort of demand in a way or ask for.
Yeah, and that's the pre-purchase side. And I was hoping, John, if you've still got a little bit of time, to stick around for our episode 6, where we'd look at the post.
I'd love to. Thanks, Pat and Mark.
Yeah, so we'll be back in a few minutes, Pat, if that's okay, and we'll have discussions on what to do at the period of settlement and risks involved there.
Oh, I love it. Some great advice there from John Melia. As Mark says, we'll come back and we now move to the next stage. So join us soon on Property Deconstructed with Pat and Mark and our special guest, John Melia from Melia Lawyers, Barristers and Solicitors.